vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte.
Morning.
Please be seated. Veuillez vous asseoir.
It's about time that we move because here is it's falling apart. Well, good morning to everybody in the courtroom, in the public gallery, and from wherever they're looking at us. I would first of all ask the court officer to introduce the case.
Situation en République du Mali, affaire le procureur contre Ahmad Faqi al-Mahdi, code ICC 0112-0115.
Merci beaucoup. Now I will ask first the prosecutor to introduce herself and the team.
Thank you, Mr. President. The Office of the Prosecutor is represented today by Gilles Dutertre, Senior Trial Lawyer, Colin Black, Trial Lawyer, Jaganaden Munisami, Trial Lawyer, Richard Nyanza Baganwa, Corporation Advisor, and Pascal Tourlon, Corporation Advisor. Thank you.
Yourself.
And myself, Mr. President, Fatou Bensouda, Prosecutor.
Thank you, Mrs. Prosecutor. Now the floor to the defense to present the team.
Bonjour, Monsieur le Président. Je suis Maître Aouini Mohamed, avocat près de la Cour de cassation au barreau de Tunis, Tunisie. Je me tiens présent aujourd'hui pour assurer la défense de M. Ahmad al-Mahdi en ma capacité de conseil de permanence. Et c'est un honneur pour moi d'être là aujourd'hui. Je suis accompagné de Maître Jean-Louis Gélissen, avocat près la Cour de cassation de Liège, Belgique. Merci, Monsieur le Président.
Bonjour, Monsieur le Président. Je suis Xavier Jean Keita, conseil principal du Bureau du Conseil public pour la défense, dont le mandat est d'assister l'ensemble des équipes de défense quand elles le souhaitent, ainsi que les suspects et les accusés. Aujourd'hui, pour cette audience, mon confrère Aouini a souhaité notre assistance. Je suis donc accompagné aujourd'hui par Madame Géraldine Danouy, qui est assistante juridique, et par mademoiselle Emel Yousfi Rocancourt, qui est consultante à l'OPCD. Je vous remercie.
Thank you very much to the Defense Counsel, to Mr. Keita. Now I will turn to the Office of the Registrar.
Good morning, Your Honor. The Registrar is represented today by Mr. Pieter van Averbeke, the acting head of the Legal Aid Unit, and myself, Thomas Henket, the Legal Counsel. Thank you.
Thank you very much. The courtroom officers are Charlotte Theron and Wilfried, can't remember, Wilfried. Myself, I'm Judge Cuno Tarfusser, single judge representing pretrial chamber 2. 1? Can't remember. I'm in both. 1. I'm in both, so I can't remember. I'm assisted by my legal team, Federica Gioia, legal officer, and Sarah Raveling, associate legal officer. For the record, I have to say that also the suspect is here, Mr. Ahmad Faqi al-Mahdi is present. So, this for the record. I will now turn to the first issue, which I think is very important. It's a language issue. Without determining the language, we can't proceed. I would ask personally Mr. Al-Faqi, first of all, I understand that he's being provided with the interpretation into Arabic. Is this correct, Mr. Al-Faqi? Mr. Keita?
نعم صحيح سيدي الرئيس.
Excuse me, Mr. Keita.
Monsieur le Président, avec votre autorisation, Monsieur Ahmad Al-Faqi Al-Mahdi souhaiterait être appelé pour toute la procédure Monsieur Ahmad Al-Mahdi et non Al-Faqi. Donc, Monsieur Al-Mahdi, s'il vous plaît.
I think also the suspect himself could have said how he would like to be addressed. So I ask the suspect how he would like to be addressed and if he is provided with the Arabic translation.
نعم سيد الرئيس، أود أن أدعى أحمد المهدي طوال هذه المحاكمة والترجمة الفورية متوفرة سيدي.
So is Arabic the language you fully understand and speak?
نعم العربية هي اللغة التي أفهمها وأتقنها. نعم.
Okay, this being the case, I would like to remind everybody to speak slowly and to pause from time to time in order to allow the a good translation, interpretation for Mr. Al-Mahdi and obviously into English and French of what Mr. Al-Mahdi is going to say. The object and purpose of this hearing, this first appearance, pursuant to Article 61 of the statute and Rule 121.1 of the Rules of the Procedure and Evidence, is first to identify correctly and fully the person who is here detained as a suspect, then to fully inform the suspect of the crimes which he is alleged to have committed, and to give him, if he so wishes, the possibility, the first possibility, to comment or to make statements in relation to the allegations in the proper judicial proceedings. Third, to inform the person of his rights inside the proceedings, and then finally to set a date for the confirmation of charges hearing. I will also take this opportunity to address a few matters concerning the organization of the proceedings leading up to the confirmation of charges hearing, and this I will do in order to ensure that the proceedings from its very beginning, from this moment on, can and will proceed smoothly, efficiently, and expeditiously, which is the right of the suspect, of course. So, this said, I come to the identification of the suspect. Mr. Al-Mahdi, I ask you, please, to identify yourself completely with name, place, and date of birth, nationality, and any other things you think is useful for your complete identification. Please, Mr. Al-Mahdi, you have the floor.
نعم سيد الرئيس، اسمي بالكامل أحمد الفقي المهدي من قبيلة الأنصار من شعب الطوارق. مواليد حوالي 40 عاما الآن، عمري 40 عاما يعني، من منطقة تسمى أغوني وتقع 100 كيلومتر غرب تمبكتو. خريج معهد تكوين المعلمين بتمبكتو، وأعمل رسميا في الموظفين الرسميين في التعليم في الحكومة المالية الفترة يعني من بداية 2011. نعم.
Thank you. Thank you very much. I would just like to remind also you that to speak slowly, because I heard just quite a pace in your answer. To speak slowly is also you have to observe for a correct interpretation from the Arabic in English and in French, if possible. Thank you very much. Now, Mr. Al-Mahdi, I come to that part where I have to inform you of the crimes you allegedly have committed. And for this reason, I ask the court officer to read out slowly the allegations in French, and French language, as French is the original language in which the arrest warrant was issued, although we attached Arabic translation. Please, court officer, here's the floor.
Il y a des motifs raisonnables de croire qu'Ahmad Al-Mahdi est pénalement responsable pour avoir commis individuellement et conjointement avec d'autres personnes, facilité ou autrement contribué à la commission de crimes de guerre, d'attaques intentionnellement dirigées à Tombouctou, d'environ le 30 juin 2012 et jusqu'à environ le 10 juillet 2012, contre des bâtiments consacrés à la religion et ou des monuments historiques, à savoir 1. Le mausolée Sidi Mahmoud Ben Omar Mohamed Aouini. 2. Le mausolée Cheikh Sidi Mohamed Mahmoud Al-Arawani. 3. Le mausolée Cheikh Sidi Mokhtar Ben Sidi Muhammad Ben Cheikh Al-Kabir. 4. Le mausolée Alpha Moya. 5. Le mausolée Cheikh Sidi Ahmed Ben Ammar Aragadi. 6. Le mausolée Cheikh Muhammad El Miki. 7. Le mausolée Cheikh Abdul Qasim Atouati. 8. Le mausolée Ahmed Foulané. 9. Le mausolée Bahaber Babadier. 10. Et la mosquée Sidi Yahya. Faits prévus et réprimés par les articles 8, 2e, petit 4, 25, 3a, à titre individuel et à titre de coperpétration directe, 25, 3c et 25, 3d du statut de Rome.
Thank you very much, courtroom officer. I note that the warrant of arrest, as I said before, has been served upon you upon your arrest in the Arabic, also in the Arabic translation, and that you are assisted by Duty Counsel appointed by the Registrar. I also note for the record that you, Mr. Al-Mahdi, have been provided with a redacted version, although I think not yet translated into Arabic, which is ongoing, of the prosecutor's application for warrant of arrest, and that the prosecutor has been ordered by the single judge to review without undue delay, and I also know that this is ongoing and that you are aware of it, to review the material, all the material, the evidence provided in support of the application in order to ensure that your right to be informed promptly and in detail of the nature, cause, and content of the charges can be meaningful, exercised by yourself and by your counsel. This being the case, I ask you now, Mr. Al-Mahdi, if you have clearly understood what you are accused of.
نعم سيدي الرئيس، فهمت بالإجمال، ولكن في التفاصيل سوف أعتمد على محامية لفهم التفاصيل إن شاء الله.
Of course. Thank you very much, Mr. Al-Mahdi. And now I will come to inform you of your rights before this court in this proceedings. First, you will be presumed innocent until proven guilty beyond reasonable doubts at trial, if there is to be a trial, and that the burden of proof lies with the prosecutor. You have the right not to have imposed on you reversal of the burden of proof and any onus of rebuttal. 2, you have the right to be informed promptly and in detail of the nature of the case and the content of the charges against you in a language you fully understand and speak, which you told me is Arabic, and which has been already done just now. 3, you have the right to have adequate time and facilities to prepare your defense and to freely communicate in a confidential manner with your counsel, with the counsel of your choice. 4, you can have free assistance of an interpreter if you need for that, if you have need for that, and have necessary translation to meet the requirements of fairness. And I think also this is, everything is ongoing in that direction. 5th, you have the right to remain silent, and you cannot be forced to testify against yourself or to have to plead guilty. 6th, you can make unsworn statements within the oral or written statement within the framework of your defense whenever you wish to do so. You have the right to receive and to have disclosed to you material which shows or tends to show. Sorry.
Pardonnez-moi, Monsieur le Juge, on a un problème d'interprétation en français qui ne passe pas dans les écouteurs. Permettons de vérifier.
Of course. Problem solved? Okay, thank you. So I will start again with the point 7. You have the right to receive and to have disclosed to you material which shows or tends to show your innocence, mitigates your guilt, or which may affect the credibility of prosecution evidence in possession of the prosecutor. 8, you have the right to challenge the charges and the evidence presented by the prosecutor and to present evidence yourself. You will have the possibility to question or to have questioned prosecution witnesses and to have defense witnesses also testify in order to present their other evidence. 9, you are entitled to waive your right to attend status conferences convened for the purpose of disclosure of evidence or other purposes, which are more technical hearings, status conferences, I mean, you have the right, and I can assure you, you will be tried without undue delay. 11th, you have the right to appeal certain decisions pursuant to Article 82 of the statute and the relevant rules of procedure and evidence. And last, you have the right to apply for interim release. I would like to particularly draw your attention this considering at any periodic review of detention does not start unless the defense makes its first application for interim release. The time limit of 120 days under Rule 118.2 runs from the Chamber's ruling on any such application. Now I again ask you, Mr. Al-Mahdi, if you have understood everything about your rights.
نعم سيد الرئيس فهمته جيدا.
Thank you very much. And now that you have been informed of the charges, that you have been informed of your rights, I ask you if you want to make, at this point in time, any comments or statements with regard to the allegations, to the facts you are accused of. Do you want to say something?
لا سيدي الرئيس فأني أرجئ تحضير الدفاع إلى ما بعد المشاورات مع محامي وفريق الدفاع.
Okay, thank you very much. Now I come to determine the date of the confirmation hearing. As Rule 121 of the Rules of Procedure and Evidence makes it mandatory to the Chamber to set at this point the date of the confirmation hearing. And after having discussed with my colleagues of the Chamber, with the parties, of course, and with the registry, and that was crucial because of the move from this premises to the permanent premises, which will happen in December, I set the date for the commencement of the hearing on the confirmation of charges for this case on Monday, 18th January 2016. This said, the hearing, first initial appearance could be closed, but I would like to raise, as I said at the beginning, some organizational matters. So in order to smoothen a bit the whole proceedings. I will touch upon 3 points. The first one is the disclosure. A decision will be filed today concerning disclosure and exceptions thereto, setting out certain categories concerning the reduction of evidence. I will issue a written decision including these categories, since reading them out right now would take some time. It might be sometimes not very clear. I would then turn to the prosecutor now and like to know whether it is possible to already provide an estimate of the amount and the nature of documents the OTP intends to rely on for the purpose of the confirmation hearing, and this is more likely to have a more precise answer, how soon the prosecutor will be in a position to start with the process of disclosure of material to the defense. I would just remind that 18th January is nearly after tomorrow, so I think we have to really to speed up, because the term is not very long, but I think it's time that we shorten a little bit this period, which goes from the first appearance to the confirmation hearing. Ms. Prosecutor, you have the floor.
Mr. President, Senior Trial Lawyer Gilles will respond to those questions.
Bonjour, Monsieur le Président. S'agissant de quand, nous pouvons commencer à communiquer la preuve à partir de la semaine prochaine, c'est-à-dire dès lors que la défense aura pu recruter un case manager et qu'elle sera donc en mesure de recevoir la preuve. Nous avons deux disclosure batch pour de la preuve de nature incriminatoire qui sont en voie de préparation. S'agissant du volume, il y a très certainement les 392 et quelques documents qui sont référencés dans notre demande de mandat d'arrêt, à quoi vont s'ajouter un certain nombre d'autres éléments à charge dont le volume n'est pas encore déterminé. Mais évidemment, tout cela dépendra un peu de l'interaction avec la défense. Je tiens à souligner qu'il y aura un certain nombre de mesures de protection qui seront demandées et qu'on va agir avec la plus grande diligence possible pour pouvoir communiquer l'ensemble de ces éléments à la défense, y compris avec des mesures de protection. En tout état de cause, le bureau du procureur va s'employer à agir avec diligence, de sorte à pouvoir être prêt dans les temps pour la date que vous avez fixée. Un dernier point, Monsieur le Président, l'accusation va déposer immédiatement après l'audience effectivement des observations sur la question des expurgations. Ça va sans doute se croiser avec votre décision et ça reprend globalement en substance le système qui est en place dans d'autres affaires, comme dans l'affaire Ongwen. On propose le même genre d'expurgation et de système d'expurgation, mais ça ne devrait donc pas étonner la Chambre de recevoir ces observations. Il n'y a rien de nouveau à cet égard. Je vous remercie, Monsieur le Président.
Okay, of course, I mean, the whole procedure should be closed by the 18th of December as or 18th or 19th, depends on the way how you calculate. But in any case, this is a period where, in any case, everything has to be disclosed. Thank you very much. The second issue I want to raise regard the time limit for the responses under Regulation 34B of the regulations of the Court. According to Regulation 34B of the regulations, in conjunction with Regulation 24.1, the prosecutor and the defense may file a response to any document filed by any participant in the case within 21 days of notification of this document to which the party is responding. This applies, according to the rules, unless otherwise provided by the court's legal text or otherwise ordered. What I'm going to do now, otherwise order, because for the sake of efficiency and avoidance of delays in addressing any procedural matter that requires intervention by the single judge in the present proceedings leading to the confirmation of charges hearing, the order I issue is the following. The prosecutor and the defense may respond to each other's filing within 5 days, not 21, 5 days of notification, in accordance with Regulation 31 of the regulations of the document to which they are responding. If and when victims are admitted to participate in the proceedings, this order will apply also to the victims, of course. After these 5 days, after expiring of the 5 days, and irrespective of whether a response is presented, a decision can and will be issued anytime, at any time. In any case, issues raised by any party would need to be decided upon with particular urgency. The other party would be requested by way of email communications and not by formal decisions to provide a response if it wishes to respond within a time limit even shorter than 5 days as appropriate. The decision would be issued upon expiration of this particular time limit set. So this is also a measure to accelerate the proceedings, because I think 21 days is far too long in any case. The third and final issue is regard the leave to appeal. In this regard, I remind the parties that interlocutory appeals under Article 82(1)(d) of the statute are to be considered as an exceptional remedy in the presence of one of the issues mentioned therein, which have to be and which will be interpreted restrictively by the Chamber. Interlocutory appeals are not a tool for expressing disagreement with the decision taken by the Chamber. Normally, the decision of the Chamber is always disagreed by one party, so, but that's not the problem. So it's not a disagreement, as very often it is perceived and it appears. Of course, I'm not referring to this case, because it's too early to refer to this case, but to my experience. And therefore, I'm saying this as a guidance to the parties. So these are the three issues I wanted to raise for the organizational matter. And if there is nothing else the parties would wish to raise by them, I come to the conclusion of this hearing. Is there something you wish to raise?
No, Mr. President.
Monsieur le Président, concernant le début de la divulgation par le procureur des pièces, le client de M. Ahmed Al-Mahdi doit juste confirmer ou indiquer dans les plus brefs délais son choix définitif. Moi, je suis encore conseil de permanence jusqu'à aujourd'hui et la communication ne peut se faire que au moins une semaine après la confirmation de ma désignation. Je souhaite que le procureur ne commence à divulguer qu'après une semaine ou 10 jours de ma nomination officielle. Merci, Monsieur le Président.
Thank you very much. This is the first time I hear that the prosecutor has to refrain from disclosing. Normally it is the other way around, that the prosecutor is always blamed for not disclosing, but it's a good reason. I think that the prosecutor will take care of this. So if there is nothing else to be discussed, I think it was quite a short and a good first appearance hearing. I come to the conclusions, and if any, of course, if any further issue, question, or problem arises between now and the date set for the confirmation hearing, i.e. the 18th of January, it will be dealt with by the single judge, either through written decisions upon submissions by the parties, or, and also here for guidance, preferably after oral discussion in status conferences to be scheduled ex officio or on request of the parties, which I think is the better way to do it instead of just throwing us papers and making decisions all the time. So, thank you very much. Thank you especially to the, I think it's difficult for the Arabic translator. Thank you very much to the translators, to all the people who made this happen, to the prosecution, to the prosecutor, to the defense, to the OPCD, court, to the registry, to my team. Thank you very much. And this closes this hearing. Thank you very much.
All rise, vous vous levez.